This video is going to give you an introduction to mock trial objections. So some basic mock trial objections. This is meant to be just an intro. It's going to introduce you to the basics of mock trial objections, but keep in mind there are always exceptions. So this is like a foundation, and as you learn more about the objections, you'll learn when and how in a much deeper sense. First thing to say, always be confident and clear. Whether you're really confident or not, pretend to be confident. You always stand when you say objection, Your Honor. So you'll say objection, Your Honor, relevance. Objection, Your Honor, hearsay. Whatever it is. Then you wait for the other side to respond. Two words you need to know are overruled and sustained. If you make an objection and the judge says overruled, the judge basically said no, sit down. If the judge says sustained, that means your objection was correct. You're right. Sit down. If you're a lawyer asking a question and the other team jumps up and says an objection and the judge says overruled, be sure to re-ask that question. Don't move on. If you're asking a question, the other team jumps up, says objection, and the judge says sustained, you cannot re-ask that question. Not unless you change it. An objection that some witnesses will do is called narrative. These are questions that ask for long, drawn-out answers. Things like, tell us what you know. Describe. Tell us about. When you hear these words, you should be thinking in your head already, is this narrative? And when the sentence is done, if it is narrative, you should jump up and say, objection, Your Honor. The question calls for a narrative answer. If the witness is already talking and they're going on and on and on, that's a clue that it's narrative. You should jump up and interrupt the witness and say, objection, the witness is narrating. Or just, objection, Your Honor, narrative. Try not to interrupt the lawyer, but definitely interrupt the witness. Relevance. This is a very common one in mock trial. Anything you ask should be related to the case, whatever the crime is. Things not obviously related can be objected to. Exceptions are asking a witness what their name is, things like that. The laying the foundation questions. For example, if it's a murder case and you ask the witness, what did you have for breakfast? That has probably nothing to do with the case. So when objecting, you stand up, you say objection, Your Honor, relevance. Lack of personal or professional knowledge. If the witness is testifying to something they did not experience themselves or something they are not an expert in, then it's lack of knowledge. Oftentimes, these are asking people to explain why someone did something or why something happened or what someone was thinking. An example would be, do you think the driver was drunk at the time of the hit and run? How would you know? Unless you're, a cop who arrested them and did a blood alcohol test at the time. If you're just, someone who watched it happen. That's lack of personal knowledge. If you ask a basketball coach to explain what created the weather patterns that caused a major accident, you have not established that the basketball coach is an expert on meteorology. So he or she cannot testify to that. When objecting, the attorney should stand up and say, "Objection, Your Honor, lack of personal knowledge." Leading questions. On cross-examination, leading questions are good, but during direct, they're not allowed, most of the time. These are questions that imply the answer in the question. For example, the monkey was under the hay bale, correct? You're telling the witness to say the monkey was under the hay bale. When did you stop stealing from the school? It's implying that you have stopped stealing and that you were stealing. When objecting to leading, the attorney should stand and say, "Objection, Your Honor, leading." Most of the time, but not always, most of the time, leading questions call for a yes or no answer. So anytime you hear a yes or a no question on direct, the first thing that should pop into your head is this leading? Hearsay. This is one of the most common objections. Hearsay is an out-of-court statement being offered to prove the truth of the matter asserted. Basically, a witness cannot talk in court about things they heard others say or things they read that others wrote. Anything they didn't experience firsthand. It's kind of like a secondary source. An example would be, "Now, Miss Smith, you say that you heard your neighbor say that he was going to kill his wife." Miss Smith can't testify about that. It's hearsay because she heard someone outside of court say it. When objecting to hearsay, the attorney should stand up and say, "Objection, Your Honor, hearsay." Argumentative. It's not very common, but it has been known to happen. This is when an attorney is questioning your witness and they're getting rough or they're getting angry with the witness. For example, "You killed your wife!" An attorney can't be angry and abusive towards a witness. They can't argue with the witness like that. If that happens, you should stand up right away and say, "Objection, argumentative," or "Objection, counsel is being argumentative." "Objection, Your Honor, argumentative." Asked and answered. This one happens fairly often. Asked and answered is when a question has already been asked and already been answered is being asked again. Attorneys will like to do this and try and get away with it so that they can make their point or get an emphasis in there. If this happens, you should stand up and say, "Objection, Your Honor, asked and answered." Lack of foundation. Lack of foundation is when an attorney begins to question a witness without first proving that he or she is qualified to answer. Example, "Coach Vang, please explain which hunting bow is the best for hunting deer." If we haven't already established that Coach Vang hunts deer with a bow, knows about the different bows, the advantages, the disadvantages, all the technical information, he is not an expert to testify. If we ask those questions first, then we've laid the foundation, and he's qualified to answer. When objecting, you should stand and say, "Objection, Your Honor." Lack of foundation. Speculation. Speculation just means guessing. Only experts are allowed to guess, and even then they're only allowed to guess about certain things, the things they're experts on. If you're an expert on meteorology, you can only make guesses about the weather, not about trajectory of bullets. Often lawyers will ask a witness to speculate about motives, intentions, or reasons behind the actions of another person. Usually these will start with something like the word why. Why do you think? Can you explain why he or she? Please explain why. If blank didn't happen, then, or they might ask, why did blank happen? An example would be, why do you think he did it? When objecting, the attorney should stand and say, "Objection, Your Honor." Speculation. Non-responsive. If the witness talks but doesn't answer the question, they're non-responsive. They didn't respond to your question. The witness may also be non-responsive or unresponsive if they give a ton of extra information that you didn't ask for. These mostly happen when you cross a witness. Because when you're crossing a witness, usually you want them to just say yes or no. You don't want them going on and on and on. If this happens, you're already standing because you're crossing a witness. So you would say, "Objection, Your Honor." The witness is being non-responsive. If this happens over and over again, other things you could say are, "Your Honor, could you please direct the witness to answer the question?" "Your Honor, I ask that the non-responsive testimony be removed from the record." Unfair extrapolation. This one doesn't happen too often in mock trial, but it does come up. This is when a witness adds information that wasn't in the affidavit, but that information they add changes the case. Extrapolation is okay. For example, if you're an expert testifying about, car engines, it probably doesn't matter if you're married or not. Doesn't change the case. If you're a police officer testifying about the case, about your investigation, it probably won't matter if you're 45 or 49. It's not going to change the case. But if a witness who did not see a crime that happened, says they saw the crime happen, they've now changed the case. If a witness starts adding things that will change the case, you should stand up and say, "Objection, Your Honor, unfair extrapolation." But only object if it changes the case. Few last things to remember. If you make an objection, be ready to explain yourself. Don't stand up, say, "Objection, Your Honor, hearsay," and then stare at everybody. Be ready to explain why it's hearsay. if the opposing attorney, if the other guy or lady asks a question, and in your head you're going, oh, that's hearsay, and that's leading, and narrative, or whatever. Don't just say one, then sit down, then say another one, and then sit down, and then stand up a third time and say the other one, and then sit down. It's just silly. Say all three at once. Objection, Your Honor. That question calls for hearsay, it's leading, and it's argumentative, or whatever. Say them all at once. Now the other attorney has to defend against all three objections. Know why you are asking every question you ask. Otherwise, when the other team calls you out on an objection, you may not have a response. One thing that I've noticed in mock trial, if you can't answer objections repeatedly, other teams will catch on to this. They'll realize that your team is weak, and they'll start making more and more and more objections. Maybe even objections they don't have a good argument for, just because they know you can't respond. And your case is going to crumble. So be ready to respond. You should be clear and sound confident in your objections. Don't stand up and go, objection, Your Honor, I hearsay? No, extrapolation. No. Relevance? Whether you're sure or not, you stand up and you sound sure. Lawyers are going to get a lot of their points in mock trial from making objections, responding to objections. It doesn't matter if you lose the objection. You might still get the points. But if you have no response to a lot of objections, you can expect to lose a lot of points. It's also nice to know the rule number for your objections. If they say, Your Honor, it's not hearsay because blah, 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 the judge turns to you and asks response. You can say, oh, well, Rule 803.1b says blah, 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 and this is... By putting the numbers out there, you sound more confident, and the judge is more likely to listen to you.